My lord, your lordship remembers that I came before your lordship earlier with regard to unauthorized construction of about 900 feet long and 5 feet by 6 inch broad particular construction with 11 pillars in the deep water. I came before your lordship. Your lordship passed an order. Kindly see the order passed by your lordship. Your lordship, kindly see the order. First of all, my lord, I will show you lordship page 34. Page 34. I made a representation to the Pradhan. I am not reading. Then, my lord, Gram Panchayat wrote to me, page 36, addressed to Aurobindo Noskar and Atunu Noskar. অজয় কুমার বিশ্বাস বেচুচারা ডিস্ট্রিক্ট অভিযোগক্রমে আপনাকে জানাতে তদন্ত সাপেক্ষে মৌজা বিপন্ন পড়া ভুক্ত জমিতে বেআইনিভাবে পুকুরে কংক্রিটের স্ল্যাব ও নির্মাণ কার্য করিতেছেন, যা প্রাকৃতিক জলাধারের সংরক্ষণ ও মৎস্য চাষের পক্ষে ক্ষতিকর। উক্ত পুকুরটি স্থানীয় জনগণের স্নান ও মৎস্য চাষের জন্য ব্যবহার করা হয়। Liability was fixed by the Panchayat upon 2 persons for unauthorized construction. Then we came before your lordship. Your lordship passed an order on at page 40. Your lordship, this petition has been filed seeking direction upon the respondent authority to remove and or demolish illegal unauthorized construction of concrete slab with deep water pillars over pond comprised within such a mauja Bibunopara, Khotianama Sajan Sat, Jumjur, measuring more or less 44 decibels. The petition alleges unauthorized illegal construction by private parties, respondent 9 and 10 over the property in question. Now your lordship kindly comes to page 42. Your lordship decided the matter by giving certain directions. 1, 2, 3, 4. Then petitioner thereafter, on the basis of your lordship direction, Panchayat gave notice to us. Panchayat held, page 46, in presence of police and local men, page 46 bottom, সকলের সম্মুখে আনুমানিক 10-12 জন পুলিশের উপস্থিতিতে আপনার এলাকার বাসিন্দাগণের উপস্থিতিতে পুকুরের উপর নির্মাণ কার্য বিহারি গ্রাম পঞ্চায়েতের নির্মাণ সহায়ক দ্বারা মাপযোগ করা হইল। Then Mara kindly see the sketch map, page 48. Herein you also will be pleased to find that the breadth 5 feet, page 48, left hand column,
5 feet. Okay.
And the in the middle there is the pond and the slab. Kindly see one slab 836. Thereafter, your lordship kindly see Panchayat, your lordship directed the Panchayat to decide the matter and to communicate the order. The Panchayat has communicated the order. I am not reading entire statement, it will take time. Now, my lord, kindly say page 50. It is kindly see page 50. the Pradhan and who after thorough inquiry would not identify who made the construction, the illegal construction. Earlier he said the two persons have constructed and their elements. Now he said, now Pradhan said, I could not identify. And it's the first paragraph, fourth line, sixth line. The illegal construction need to be demolished. Moreover, the meetings also. It is specifically stated that, in my opinion, Dr. Ajay Kumar বিশ্বাস, owner of the pond, has not made the illegal construction in question. As such, representation dated disposed of with above reasons. Then, my lord, following signatory such and such, then the Gram Panchayat, kindly see page 51. Gram Panchayat has no suitable infrastructure to demolish of the above mentioned illegal construction. Page 58 top. The Gram Panchayat has no suitable infrastructure to demolish for demolition of the above mentioned illegal construction under the provision of
What is the order passed by the
subsection 5 of
sub-divisional-
section 23
What is the order passed
of the
by
West Bengal Panchayat Amendment Act 2000. So the matter is being referred to the learned
What is the order
sub-divisional
passed by the
officer.
divisional officer?
But we are only one. I cannot demolish the particular because it's a serious matter, serious commotion. Vast police force will be required. I want that the SDO under the law, SDO is the competent authority to demolish, and I will bear the cost. Kindly see the rules. Kindly see the amendment of the act.
Sub-divisional officer.
It is the
Hold on.
it is the
Now,
it is the it is the power of the SDO. Kindly see the amendment. The amendment. মাংতে বলেনি
দিন তো
না 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 এটা দিয়ে ওকে পাঠিয়েছে না দেখি দেখি না না এটা তো পঞ্চায়েতকে বলেছে পড়োনি
Why?
Now, my lord, in the meantime, SDO wrote a letter to the Panchayat that you demolish, that you ask the owner to demolish. Can't you see? Say subsection 5
was fine.
of section 23.
Where is the letter?
In the meantime, SDO has written a letter to the Panchayat Pradhan that to direct me to demolish. I say that I cannot demolish. It is a serious matter. I want the I want the implementation of subsection 5. My lord, kindly see subsection 5. Section 23, subsection 5. Kindly see subsection 5. Subsection 5 says, and on the basis of the same, Gram Panchayat wrote a letter to us to demolish on 11 July. Last paragraph. Now, my lord, under subsection 5, my lord, can you see subsection
This
5?
for the state.
Subsection 5
Now
says,
the sub-divisional officer has again sent the ball to the Pradhan's court, and he is directing to you now direct the recorded owners to remove it. Why? 23(5) does not say so. The sub-division officer will directly send to the person who has made such construction, giving 15 days time, you remove the, or I will take steps. Now what he has done, he sent it to the Pradhan. Pradhan has passed order, see, I have given you notice, I don't know who has made construction. This will go on. He starts with the sentence that is being established that is illegal construction. Now whose responsibility is to remove? If the owner is not doing so, you tell me why he has passed such an order? Is due. 23(5) does not say that he has to redirect the same to the Panchayat Pradhan.
May I submit it to mention?
Your chapter is over.
Yes,
You have passed a reasoned order.
Order, therefore matter is referred to the subdivision officer Southern Howrah.
Hmm.
Now, when the hearing has been made, in the meantime, second writ petition arrived before the SDO at the time of meeting in presence of all the parties. And the second writ petition prayer, my lord, you will also kindly see the page 29. The prayer of the second writ petition, that is this petition, my lord, prayer. The respondent number issue a mandamus commanding upon the respondent authority, particularly respondent number 4, to direct the petitioner first to demolish the said illegal construction, namely such and such. The petitioner himself, they make self-demolish, my lord, according to the prayer, my lord. When that prayer was made before the subdivision officer Howrah, thereafter the matter was sent for passing. You will also kindly see the page 29.
Who is respondent number 4?
My lord, we wanted that we said to we said to the SDO that it is not possible for us. We cannot demolish.
They will make
Please stop. We cannot demolish because it will require various police people and local commotion of local people is there. Police commissioner has to intervene. As such, you will also kindly subsection 5 of section 23, my lord, kindly see.
and the
Section-
representation, my lord, representation
Take it, sir.
dated 24 April 2024 at page 34, page 35 specifically mention the name of the person who have made the construction. That means on the basis of the petitioner's allegation, they made in representation at page 35, the person name has come in. At the time of hearing in presence of all the parties, no one said that "Look, I have been made construction." That's why all the matter is sent down before the subdivisional officer according to the Panchayat law. And at the time of hearing in presence of all the parties, learned friend does not appear because they have been filed a second writ petition. And on that date, the postal peon has been served the second writ petition before the meeting. On the basis of the prayer, now the order has been.
This petition we filed, not second petition. This petition we
This
filed.
petition, this instant.
This petition. Don't say
You will
second
demolish
petition.
that.
We filed this writ petition.
Why you
We
have
said
sought for
that
leave
we
to
cannot
file?
appear before you.
Huh?
As such, my lord, we are making a prayer before your lordship on the basis of the order of the SDO that to invoke section 23, subsection 5 by directing the SDO to demolish, because law says SDO is the competent authority to demolish and all the costs I have to bear.
Just
Kindly
like
see subsection 5.
Mr.
Kindly see subsection 5.
Try to understand. Mr. Bhattacharya, nothing has been stated in this writ petition about the order passed by the SDU. You are not agreed by the order passed by the SDU.
এসডিওর যে অর্ডার আছে সেটাতে আমরা কি এগ্রিড
We are aggrieved.
Agreed. Then where is the prayer?
But at that point when we filed the writ petition, we did not receive this letter. We have received the letter after the filing of our writ petition.
Then
At
how
that
can
time, we did not
pass in
receive.
this writ petition?
Kindly see the your lordship, the order dated of the SDO.
How can that order be passed in writ petition?
SDO is dated 5th of June 2025. We
Then
filed the writ
beyond the scope
petition.
of the writ petition right
Kindly
now.
see,
He has rightly pointed out. Now you have sought for leave that you will demolish that.
we filed the writ petition. We filed the writ petition on 19th May. 19th May. We received this letter of SDO on 5th June 2025.
Cannot help it.
And
Withdraw this
There
writ
are-
petition, file afresh. I am granting you liberty. Incorporate those facts. It has to be withdrawn. Incorporate that fact that
Then
order,
I will file
that direction has to
supplementary
be given to
affidavit
the
and
SDO
meet the prayer.
to act on his own capacity, not to direct it to the Pradhan. 23(5) says he will take steps. Now, if the recorded owner, whosoever has made construction, does not come up, does not say that I have made, then he will demolish that. But if that order is not challenged, how can that withdraw this, granting you liberty, incorporate that order in the writ petition? Mr. Milan Kumar Bhattacharjee, learned senior advocate, appearing for the petitioners. Milan Chandru submits that the SDO has passed order on 5th June 2025 directing the Pradhan, instructing the Pradhan to direct the recorded owners to remove the illegal construction within a period of 20 days.
Thereafter,
However,
we received the letter of the Panchayat. Kindly record this.
since
We received the order of the Panchayat to demolish.
which has been served. No, this is not that order. This 5th June 2025 is the order of the subdivisional officer.
My lord,
5th June is the order of the subdivisional officer.
yes. But Panchayat subdivision cannot delegate, my lord.
Act to kindly then.
No delegation power.
Thereafter, he has received a letter from the Pradhan asking the petitioner to demolish the unauthorized construction, which is unheard of so far as section 23(5) of West Bengal Panchayat Act is concerned. He seeks to withdraw the writ petition with liberty to file afresh incorporating such facts. In view of, he files copy of the order of the subdivision officer dated 5th June 2025 and letter of Pradhan dated 17th June 2025, which is taken on record. In view of the submission, the writ petition is dismissed as withdrawn with liberty to file afresh. এটা দিয়ে দিই।
ওরা দিচ্ছে আমাদের নাম। আমাদের
দিচ্ছে যখন
হ্যাঁ my lord,
I am appearing on behalf of the petitioner, my lord. Affidavit service. In this matter, my lord, gross injustice upon the my lord writ petitioner, my lord, who my lord the Panchayat Kormi my lord appointed in the year of 2006. Thereafter, time to time transfer before the different Gram Panchayat. My lord, there is a circular, my lord. If there is a 5 years, my lord, in the service, in that case, as per choice of the petitioner, the authority will place in the said Gram Panchayat nearby the resident, my lord. My lord, it is a very interesting fact, my lord. Kindly see, my lord, the page in para number 3, page 2. The petitioner joined in the 2006, thereafter, my lord, transfer in the year of 2024. Very well, my lord, I did not make any objection. Thereafter, my lord, the wife of the petitioner also, my lord, service in the Asha Kormi in the same Gram Panchayat, the permanent resident, which also milord in the circular made that if the wife is milord there, in that case, he is also entitled to milord. That's the difference. Milord, thereafter, milord, kindly see milord para 5 in the page number 4. When the authority again issued a transfer order on milord, before that, milord, 6/1/2025, milord, transfer order issued, milord, kindly page number. Page number 10, milord, first of all.
Page number.
Milord, present posting Kanuri, thereafter Gogoda, milord, transfer. Serial number 5. Kanuri is the milord home posting, thereafter milord transfer to the another place. Thereafter, milord, page number 12.
What is your name?
Gogoda
Haradhan.
Haradhan Sadhu. Thereafter, milord, in the year of milord 2025, Gogoda to Salma. Milord, the petitioner raised objection, milord, because petitioner milord going to milord retired October 2028. Thereafter, milord, page number 13. Milord, the cancel that transfer order on milord next day, or the date was not given, milord, but 10th January 2025. First, milord, the SMS, page number 13. Transfer order, page number 12, and through SMS, milord stated that the orientation program BB Bengatur will be held on such and such. Thereafter, ignored the email sent for GP Kormi, transfer order, corriendum will follow soon. But transfer order, milord, directed, follow soon thereafter. Thereafter, milord, page number 14. After cancelling, milord, thereafter, again, milord, kindly see, on 11th February, milord, cancel on 10th January. Thereafter, milord, after 1 month, again, milord, issued a transfer order. Page number 14. But I made a representation on the next date, 12th February, page number 15. Milord, did not consider, milord, I filed a writ petition on milord 17th. After milord receiving the copy of the writ petition, milord threatened, milord, if not join in the transfer milord place, in that case, milord, suspend, nothing, milord, whatever, milord. The petitioner, milord, both the kidneys were, milord, problem, all the milord documents, milord, annexed, page number 16 onwards. Knowing fully well, milord, after few days, milord, transfer order, milord, passed one after another, milord. And milord, circular, milord, kindly see, issued by the milord joint secretary of the Panchayat department. There is a clear mention, milord, if your lordship, milord, kindly, milord, serial wise, milord, kindly going through, in that case, milord, it will be clear. প্রথম নিয়োগ করা হবে জেলার মধ্যে প্রাপ্ত যে কোনো শূন্য পদে, 5 বছর পর পর বদলি করা হবে। যে ব্লকে কর্মচারীর বাড়ি যথাসম্ভব তার কাছাকাছি ব্লকগুলি, মিলট গট ইট, মিলট, পেজ নাম্বার 2 ইন দ্য সার্কুলার। গ্রাম পঞ্চায়েত কর্মী হলে যে গ্রাম পঞ্চায়েতে বাড়ি তথা সম্ভব তার কাছাকাছি গ্রাম পঞ্চায়েত বদলি করা হবে। চাকুরি জীবনের শেষ 5 বছর কর্মচারী পছন্দ মতো নিজস্ব ব্লকে, মিলট, মাই রিটায়ার্ড ডেট মিলট October 2028. The transfer order issued February 2025. So, in any case, milord, the authority, milord, not in a position, milord, to transfer me, milord, without my consent. And why, milord, in the month of January, milord, issued a transfer order. That order cancelled. Thereafter, in the month of February, again transfer order issued for different place for adapting pick and choose policy, milord. Some persons who is interested to, milord, posted in the Kanuri Gram Panchayat, in that case, for milord, give a benefit to that person, milord, the petitioner, milord, deprive. So, milord, they violated their own circular. Less than 2 years, milord, my service, and I am suffering from, milord, kidney disease, milord, all the documents, milord, annexed here. And as per circular, milord, I am entitled to get the milord, posting as per my choice.
How far these two places, sir?
Distance, milord. Distance, milord, about, milord, Kanuri, my, milord, home posting, my wife also there. and it is a different gram panchayat. It is near about, but there is no communication because there is a land long distance without conveyance walking distance 2 or 3 kilometers. 2 and 3 kilometers. Under threat, compelled to join during pendency of the writ petition. The video.
You have joined.
Yes, join I am not in a position. Every day, with car, I am coming and going due to kidney disease. Otherwise, the third I have suspended or dismiss my service. Last 2 years, my service in that case, I not got chance, not get any risk.
Ashwin, affidavit of service filed on behalf of the petition is taken on record. Mr. Munishankar Chattopadhyay, learned advocate for the petitioner, submits that the petitioner joined as Gram Panchayat Karmi at Ekhiya Gram Panchayat in the year 2006. Thereafter, he was transferred to Kanuri Gram Panchayat.
Kanuri. Thereafter, Gogra.
And thereafter, he was transferred to Gogra Gram Panchayat. The petitioner is about to retire in the year 2028.
October 2020.
October 2020. Going to retire. The petitioner is suffering from various ailments, particularly what is the ailment now? You say?
Yes,
What is the ailment? What ailment he has been diagnosed?
Diagnosis for kidney disease,
Kidney disease, particularly kidney disease. The petitioner had to travel a long distance to attend his office. Where is your representation?
Representation, page number 15.
The petitioner made representation before the concerned authorities for redressal of his grievance. However, no steps has been taken, and the petitioner has been forced to join his new posting at Tiluri.
Tiluri Gram Panchayat under compelling circumstances.
Tiluri.
TILUR at Tiluri.
Under compelling circumstances. Hence this writ petition. Learned advocate for the state seeks accommodation to take proper instruction. Oh, sorry, I don't know. As per the circular issued by Joint Secretary Panchayat and Gramunnayan Department, the petitioner ought to have transferred to a place which is close to his house. It had told that he has to attend office. Attend office at a distance. ওইটার আগেই sentence চলে গেল। State is directed to furnish a report in the form of affidavit on the returnable date. List this matter 2 weeks hence after 2 weeks under the heading a returnable motion. Advance copy open the advance copy of the report we find 1 week the report the 1 week 1 week and 1 week কোনো exception দেবে না 2 weeks এবার date বলতো returnable motion Fourth August. File a report in the form of affidavit, give an advance copy to him 1 week, and 1 week you file your exception to such report.
My lord, kindly one in the my lord, kindly in the fix in that same top position, my lord.
Top position, top এ দিয়ে দাও টপে আসছে তো হ্যাঁ একটা ফেরত দিয়ে দাও
I have a copy, my lord. It will written.
Next.
My lord, I am for the petitioner. As per instruction from the advocate on record that petitioner does not want to proceed the instant case, but right now I don't have the letter, my lord. I am praying for not this week only.
What on behalf of the state kept on record, my lord.
Not intending again a date will be fixed on which he will produce.
My lord,
his-
I am not the advocate on record. I only
Who is the
request
advocate?
Mr. Comrade Banerjee, perhaps.
He has not come. He has come.
No, he due to illness he could not come to court today.
Here of learned advocate for the petitioner. Sorry. Learned advocate for the petitioner submit that the petitioner does not intend to proceed with the writ petition. However, he seeks accommodation to produce a written instruction. Tuesday.
Grateful.
Tuesday to be mentioned.
Grateful, my lord.
By the state may be kept on
The
record.
report filed by the state is taken up. Tuesday to be mentioned.
Grateful.
22nd to be mentioned.
In item number 61, Lordship, I beg to appear on behalf of the petitioner, Lordship. This is my affidavit of service. Lordship, in this matter, the petitioner, who is a voter within the jurisdiction of the Hooghly Jila Parishad, who has contested an election from the constituency number 53, Hooghly Jila Parishad from a recognized political party. Lordship, that is Bharatiya Janata Party, from which the petitioner elected in that particular seat. After contesting, Lordship, there is total in number, there is 51 seat in Hooghly Jila Parishad, Lordship. Out of that 51, that the 49 has been owned by the ruling dispense and 2 has been owned by the by the opposition party, Lordship, that is Bharatiya Janata Party. Now, the petitioner herein, Lordship, has elected from a constituency within Khanakul 2. Now, Lordship, subsequently, what happened, Lordship, that so far the act is concerned, Lordship, there is a position of leader or in opposition in the Jila Parishad, Lordship, that has to be selected by the concerned authority. Now, Lordship will find from page number 27, Lordship will find my certificate of election, which indicate that, Lordship, I have contested and then after on 11 July 2023, I am declared as a own candidate from Khanakul to GP 53 constituency. Now, Lordship will come to the page number 28.
Page 35.
Page 29, Lordship. 27, Lordship. Page 26 is the voter ID epic card, Lordship, and 27 is the document which shows that the certificate of election that has been issued in favor of the petitioner from my writ petition, Lordship. Now, that shows that Lordship, I have the candidate declared winning candidate in that particular constituency under the Jila Parishad constituency that has been declared on 11th of July 2023. Now, Lordship will come to the page number 28. Lordship will find there is a representation made to the concerned authorities for my selection as a leader of the opposition. That has been duly communicated, and the following pages are the communication, document of communication. Now, Lordship will come to page number 33, that is annexure P4. Now, it has been, Lordship, annexure P4, page 33.
33.
Yes, Lordship, annexure P4, page 33, annexure P4. Lordship has found. Now, Lordship, that is a memo which has been issued via number 1673/PNRD, that is dated on 1st of July 2024. It's a reminder regarding the submission of proposal for the opposition leader of Hooghly Jila Parishad and opposition member of Sthayi Samiti of Hooghly Jila Parishad. Now, Lordship, I pause here for a moment, Lordship. Now, what is the Jila Parishad and the Sthayi Samiti, Lordship? I have to indicate. Lordship will find from this Act, Lordship, under section 171 of the Panchayat Act, it has been specified, Lordship, that there is a Sthayi Samitis of the Jila Parishad. Section 171 of the West Bengal Panchayat Act 1973. Now, it is indicated that, Lordship, that the Sthayi Samiti, one, a Jila Parishad shall have the following Sthayi Samitis, namely Ortho, Shastro, Unnayan o Porikalpona Sthayi Samiti, Jonosastro o Poribesh Sthayi Samiti, and such, Lordship. Now, Lordship, kindly come to section 2. A Sthayi Samiti shall consist of the following members, namely the Sabhadipati and Sohokari Sabhadipati ex officio, and B, without prejudice to the provisions of this clause, B, not less than 3 and nor more than 5 persons to be elected in the prescribed manner by the members of the Jila Parishad from among themselves. Now, Lordship, kindly come to the BB. It has clause BB, Lordship, it has been stated that leader of the recognized political parties in opposition having the largest numbers of members in the Jila Parishad in comparison with other recognized political parties in opposition shall be a member of the Ortho, Shastro, Unnayan o Porikalpona Sthayi Samiti. Now, Lordship, these Samitis, I would have been selected as a member of these Sthayi Samitis. Now, so far the Hooghly Jila Parishad, and after the election of 2023 is concerned, there is only 2 members who have been elected from the opposition, and rest of the other person is from the ruling dispense. So, out of these 2 persons, one should be selected as a leader of the opposition in the Samitis. Now, Lordship, I just come to the writ petition. Lordship, kindly come to page number 38, Lordship. That has been issued by within the pad of the Bharatiya Janata Party, Arambagh Warji district. It was issued on 14/8/2024 to the additional district magistrate. That is a proposal from the recognized political party that I am writing to formally propose the appointment of an opposition leader of the Hooghly Jila Parishad. I would like to recommend Mr. Kalipada Adhikari as an opposition leader. I kindly request you to consider this proposal and take the necessary step to appoint an opposition leader in the Hooghly Jila Parishad. I confident that this will contribute positively to the government and administration of the district. Thank you for your attention to this matter. Look forward to your favorable response. Now, Lordship, so far the earlier communication is concerned, Lordship will find from page number 33. It has been stated that it should be forwarded through the recognized political party, and that same has been communicated to the concerned authority. But then after, Lordship, it's still in a idle position, Lordship. No decision has been taken from their part, Lordship. Now, state is the answering respondent, Lordship. State is in the better position to answer to these queries, Lordship.
Question number 1, 2, 3, 5. The Hooghly Jila Parishad is not the answering respondent. I do not know whether they have their own system. But the cause of action is at page 28.
Is not a party here, Hooghly Jila Parishad?
Yes, smart.
Yes, they are the party, Lordship. We have served upon them. Now, Lordship, may I just indicate one thing, Lordship? So far, the page 33 is concerned, the state is the answering respondent.
Jila Parishad as a body has to be implemented as a party responsible.
They have parted. We have added them as a party.
Chairperson has been implemented as party.
Jila Parishad.
Body corporate board has to be implemented as a party responsible. That is the requirement of law. That is the requirement of law.
But so far, Lordship,
This is the requirement.
so far the communication to the president is concerned, that has been made by the additional district magistrate.
The whole Jila Parishad as a body corporate, Jila Parishad has not been made a party.
We made chairperson as a party,
No.
but if at all it is required, Lordship, we can amend. But so far the page 33 is concerned, Lordship, that the requirement
Unless and
for
until
the
Jila Parishad-
opposition leader, Lordship, that has been indicated by the additional district magistrate only.
If your lordship kindly takes note of the requirement of statute,
140
section for 140 subsection Roman 4.
140 Roman 4.
No, only 4 minutes.
Every Jila Parishad shall be body corporate.
Jila Parishad shall be a body corporate having perpetual succession and a common seal and shall by its corporate name sue and be sued. So Jila Parishad independent has to be made a party member. The chairperson has been made a party.
কিন্তু হচ্ছে এইটা তো ইস্যু করেছে অ্যাডিশনাল ডিস্ট্রিক্ট ম্যাজিস্ট্রেট বলছি আমি বলুন না
But Lordship, so far the requirement of the additional district magistrate is concerned at page number 33, Lordship. We he's the answering respondent, and prior to them, Lordship, we have replied.
Filed on behalf of the petitioner is taken on record. It is so and so, learned advocate for the petitioner submits that as per section
171, Lordship.
171 of the West Bengal Panchayat Act 1973. Leader of a recognized political party in opposition having largest number of members in the Jila Parishad in comparison with other recognized political parties in opposition shall be a member of Ortho, সংস্থা, উন্নয়ন ও পরিকল্পনা স্থায়ী সমিতি। The president of the
Lordship, president of
Janata Party,
Bharatiya Janata Party, Arambagh, ORG district.
Arambagh ORG district. Video later dated 14th August 2024. Recommended the name of the petitioner, Mr. Kalipada Odhikari, within bracket, Jila Parishad -53, as an opposition leader. Made a communication. Made a communication. Video later than such address to address to
Additional
to
district
magistrate PNRD Hooghly, recommending the name of Mr. Umuk as leader of opposition.
In reply to the
However,
memo,
yes,
in reply to the memo of the issued by the additional district magistrate.
in
That
reply to
the memo issued by the additional district magistrate PD, that is fired memo number 1673/PNRD
reply
dated
to
1/7/2024.
the Page number 33.
Page number 33 is the memo. Reply to the memo they have issued.
Reply to the memo of the Additional District Magistrate PNRD dated 1st July 2024.
1st July 2024, Lordship.
However, till date, no, so now the Additional District Magistrate will issue a letter of your appointment as a,
Yes, Your Lordship.
however, no steps has been
They have
taken
to answer to this
since
request.
August 2024. Since then, Gordon. Hence this writ petition. Mr. Shantanu Kumar Mitru, learned senior counsel for the state. At the outset, submit that the writ petition is bad for non-joinder of parties since Hooghly Jila Parishad has not been implicated as a party respondent. As per the West Bengal Panchayat Act, section 146, no?
140 subsection 3. Subsection 4.
140 subsection 4 of West Bengal Panchayat Act 1973, the Jila Parishad is a body corporate and therefore has to be implemented as a party. In view of such submissions, leave is granted to the learned advocate on record for the petitioner to implement the Hooghly Jila Parishad as a party respondent number.
There is not a 7 respondent, it will be as 9 or 8, Lordship.
Party respondent number 9. Regulation to serve upon. Cause a service upon the Hooghly Jila Parishad. Come back. When can this be completed?
After 1 week, Lordship.
The next week again.
Preferably on top, Lordship.
In the meantime, you take instruction why the additional district magistrate not acted. He has asked for the name, they have sent the name. So why it is? Huh? 25th. মানে নম্বর বলছো নাকি ডেট বলছো? ডেট 25th তো
25th, preferably on top, Lordship. They will come with the instruction, it will be distributed. Preferably on the top.
we'll see how it is. বলতে পারবো না টপ তুমি আগে অ্যাপিয়ার করুক ওটা নিয়ে আসুক রিপোর্ট
Lordship, preferably on the top, Lordship. It will take only few minutes, Lordship. I will after that.
you serve and then mention
I will
take it up
Careful to your Lordship.
with the
Careful to your Lordship. Number 7 and 8.
My lord, I am for the petitioner, my lord. My lord, my specific allegation is without having sanction plan, my lord, private respondent making unauthorized construction over the Panchayat village road, over the
service
yes.
you are for the private respondent
Yes, my lord, I am for the private respondent number 7 and 40.
state Pradhan is respondent number
My lord,
Pradhan is respondent number
yes, Pradhan is respondent number, my lord, 6. My representation is page number 36.
563 oh. Yes.
My lord, private respondent without having sanction plan, their construction unauthorized construction over the Panchayat village road, as well as encroaching my plot of land and without maintaining the open space, my lord. This is my specific allegation. My lord, kindly come to page number 36, my representation.
Okay. What is your submission?
Lord, they have mentioned this matter, my lord, without serving notice. My lord,
Without serving notice?
without, yes, my lord, without serving notice to us.
Okay.
প্রাইভেট করলে দিছো বলছে
Then how do you come to know? Who is Nabo Kumar Das?
We got this,
Subrata Ghosh?
my lord,
You are?
yes, gives the notice for upgradation to us.
My lord, my, Alauddin Biswas and Mujibur Rashid
Now, what is your submission now that you have come?
has given to us, my lord,
are we affected in the
What is your submission?
my lord, so, kindly call a report from the Pradhan, my lord,
Sending it back to the Pradhan.
or kindly send back to the Pradhan, my lord.
my lord, direction may be specific direction may
I
be
have
given up.
released all my documents, my lord.
You are to follow. Affidavit service filed on behalf of the petition is taken on record. This writ petition is filed seeking direction upon the uh, respondent authorities to take immediate steps for demolition of the illegal unauthorized construction made by the private respondents and to consider the representation of the petitioner dated 1st March 2025. The petitioner alleges of unauthorized illegal construction by the private respondents. Where is the representation?
My lord, page 36.
Over the Panchayat Road. Encroaching the land of the petitioner situated comprised with the LR plot number 705, Khutian number 779, jail number 95, and খতিয়ান নম্বর বললাম and আরেকটা খতিয়ান নিন। আচ্ছা ওটা পরে নিন, হ্যাঁ এটা এরকম করুন। এলআর প্লট নাম্বার ঠিক, জিএল নাম্বার 95, মৌজা সুজনি পাড়া, হ্যাঁ খতিয়ান নাম্বার 779, measuring about 2.0500 শতক, and খতিয়ান নাম্বার 781, measuring about 0.0374. Such unauthorized construction has been undertaken without any permission from the panchayat, local gram panchayat. The petitioner made representation on 1st March 2025. However, no steps has been taken, hence this writ petition. Mr. So and so, learned advocate for the petitioner, submits that the direction be issued upon the Pradhan to consider and dispose of the representation of the petitioner. Learned advocate for the state as well as private respondent also submits that the matter be relegated to Pradhan to cause inquiry. Stop. তারপরে যেটা থাকে এই পয়েন্টস গুলো, আর এখানে লিবার্টি পার্টিসদেরকে একটা ক্লজে বলে দেবেন, পার্টিস আর গ্রান্টেড লিবার্টি টু প্রডিউস অল রেলেভেন্ট রেকর্ডস and document before the disposed of. Liberty granted to the parties to produce all relevant records before the Pradhan at the time of hearing. He will cause inspection, prepare a sketch map, and thereafter dispose of. Wait, too much.
I am for the petitioner. My simple case that it is a domestic house. The private respondents have made illegal and unauthorized construction on the terrace of the first floor, and they have also made illegal construction by totally blocking my staircase and drainage system. I made several representation.
My lord,
My lord, page number 4,
my lord,
page number 31.
my lord,
pa-
Mr. Rajdeep Pramanik is appearing for respondent number 9 due to his medical illness. He is unable to come before court. Kindly make it 1 week.
Only respond number 9.
Private respondent number 9.
What about the other private respondents? All served?
I have served.
Where is the affidavit of service?
Presently, I am not with the affidavit of service. But I served. They have got they
On the prayer of learned advocate for the
my lord,
petitioner seeks accommodation to file affidavit of service. No. 2 সপ্তাহ পরে ডেট দিন।
my lord, affidavit of service is ready.
Where is that?
They have got they are respondent number 9. They have got the state authority has also
Where
appeared.
is the affidavit of service in respect of the rest of the private respondents? If it is there, file it.
My
If
lord,
it is not there, then I am
matter-
granting you time to file.
But it is our fault because the affidavit is not with us.
So why before mentioning you are not sure that whether this has been served,
It
affidavit
was-
is ready or not?
My lord, it was with us, but unfortunately today it is misplaced. It was
Anyway, it will come up after 15 days. Get the affidavit of service and file.
my lord, kindly fix it on the next on the next date. Thursday, next day, my lord.
এই থার্সডে দাও,
next-
নেক্সট থার্সডে না, তুমি 15 দিনের মাথায় দাও। ওর অ্যাফিডেভিট অফ সার্ভিস করে আসো ফার্স্ট।
In this matter, I am appearing on behalf of petitioner. Well, here is the affidavit of service, it's served all. And when I am praying lordship can leave to file a supplementary affidavit. Annexing a document which was not available on the date of filing of the application. But fact in short is this, that on 21st of February 2025, notice inviting tender was issued by Nadia Jila Parishad for settlement of Tehotto Chokbihari ferry service. On 13th of March 2025, it was open. 4 persons participated there. The person who was declared as successful bidder, his bid money was 2 crores and 53 lakhs and odd. Lordship kindly come to page 20 of the original writ
You are
application.
representing state.
Lordship kindly come to page 20 of the writ application. This is the notice inviting tender. Clause 7, Lordship kindly come to. An agreement will be signed between the Nadia Jila Parishad and the successful bidder to run the tank for 3 years. Upon payment of 100% of the bid amount, failing of any of the above conditions, it will be treated as cancellation of the agreement and the earnest money will be forfeited. Where he has deposited only 30,000, the bid money was 2 crores 53 lakhs and not. Lordship, can I come to the supplementary affidavit? P7. আমরা সার্ভ করেছি I have served. Here Lordship kindly see page 13. This is dated 21st of April 2025. In the second para, Lordship will find the lease period will be from 22nd of April 2025 to 21st of April 2028, 3 years, subject to fulfillment of all the conditions of the above stated notice. This is what I am praying before your Lordship at this stage. Let a report be called for from Nadia Jila Parishad, whether on the date of handing over position, that is dated 21st of April 2025, entire bid money was deposited by the successful bidder or not. If he has not submitted, then as per the notice inviting tender, bid would be cancelled. First, Lordship kindly call for the record. Nothing more, nothing less at this stage I am asking for.
Okay. What is your case that they have not deposited?
They have not deposited. They have only deposited 30,000. Very well. Submit a report.
Affidavit of service filed on behalf of the petitioner is taken on record. On the prayer of learned advocate for the petitioner, leave is granted to file supplementary affidavit. Supplementary affidavit filed on behalf of the petitioner is taken on record. Give a copy to him.
We have already filed.
Sir, again, sir.
Okay. All right. All right.
He has not received from his office. Give him a copy. Mr. So-and-so, learned advocate for the petitioner, submits that as per clause 4,
Clause 7.
clause 7 of the
Notice inviting tender.
notice inviting a tender,
Dated 21st of February 2025.
the agreement will be signed by the Jila Parishad and the successful bidder to run the tank for 3 years upon payment of 100% of the bid amount. Failing which, the deed will stand cancelled. Failing which, there will be cancellation of the agreement and the earnest money will be forfeited. Clause 7. the who is the private respondent?
Private respondent Rajab Mandal.
That is
He has been served. Have checked. Which page?
Affidavit, affidavit of service or copy to Respondent number 12.
But which is the page now? 302. 302. Yeah, deliver. ठीक है. কি বলুন? He submits that the successful bidder, namely respondent number 10, 12, has not deposited the entire bid amount as required under the e-tender notice, and therefore his agreement is liable to be cancelled. He seeks that a report be called for from the Jila Parishad in this regard. None appears on the state is unrepresented. Stated panel represent. Anybody from the state panel present in court? Mr. Lighty is there. You'll appear in this case. None appears on behalf of the state is unrepresented. Mr. Lighty, who usually appears on behalf of the state, is requested to appear in this matter. Let the appointment of Mr. Lighty be regularized by the concerned authority. The advocate for the petitioner is directed to hand over a copy of the petition along with its annexure to Mr. Lighty. State is Jila Parishad. This Nadia
Yes,
Jila Parishad is
Nadia Jila Parishad.
directed to file a report in the form of affidavit disclosing the relevant facts, particularly as to whether respondent number 12 has deposited the entire bid amount or not. State, you also file a report?
liberty may be given, my lord. If it is required, my lord, we will.
Liberty is granted to the state to file. Yes. The liberty is granted to the state to file report, if any, on the returnable date. The point of maintaining the writ petition is kept open and shall be decided at the time of final disposal of the writ petition. Release this matter. अच्छा उनके टाइम दिए था. How long? 1 week? Within a period of 2 weeks करो report जरा file कर दो. Advance copy be handed over to learned advocate for the petitioner. 1 week you file your exception. Release this matter after 3 weeks returnable motion.
Wait. 3 weeks.
Despite service, none appears on behalf of this one. What about the hearing down? Pick you up.
Item number 8
List again.
of your lordship's list today.
Yes.
I'm mentioning upon notice. Well, this is a matter where a foreign award was found to be inexecutable by your lordship. We've taken an application out for review. There's some urgency, my lord. If next Thursday it could be given some precedence, eventually, my lord, direction for affidavits will happen. Because to be candid, there is a delay of 79 days. They will file an affidavit. So that 1 minute also, if it's taken up, there'll be some consideration could be given to it be taken up next Thursday.
Sure. Who is on the other side who argued?
I've mentioned, Manoj, we mentioned upon notice. I've served the notice. And I'll also intimate the other side if your lordship gives it some precedence, Manoj, I'll mention it.
In the other side, because in presence of both the sides, I can fix a date because only on Thursday I'm taking up the original side matters.
Yes, Manoj, next Thursday, if your lordship gives it some precedence, if it can appear item number 1 or 2, then I'll accordingly intimate, and then a date can be fixed on that day, or it can be. It'll actually take 5 minutes because they will file affidavit.
এখন করা যাবে না। You mention after some time. Mention after some time.
Very good. I'll try my luck next Thursday again.
My lords, kindly, my lord, to mention one matter from the appellate side. Since it's not taken up, my lord, item number 68 may kindly be upgraded, taken up next Thursday. Anytime that.
68 or
68 of the appellate side list, my lord.
not now? Mention it listed.
I was to conclude my submissions, Your Lordship. Most concluded. On the last occasion, Your Lordship, I had addressed the court on the issue that despite not serving the PLA, why the affidavit of service should have been filed. I had shown the provisions, Rule 25, Section 236 of the Indian Succession Act, and I had also drawn attention to the fact that all the requisite information that are mandated to be disclosed in the PLA, they were already in the knowledge and information of the caveatrixes. And apropos that, I had just requested your lordship to kindly take section 278. That is exactly where I had stopped on the last occasion. Section 278 of the Indian Succession Act. 278.
Yes.
Stipulates what are the contents of a petition for letters of administration. Your lordship will kindly see what are the requisite information. 278(1). Your lordship has found that application for letters of administration shall be made by petition distinctly written as aforesaid and stating A, time and place of deceased death, the family or other relatives of the deceased and their respective residents, the right in which the petitioner claims, the amount of assets which are likely to come to the petitioner's hands. When the application is to district judge or the deceased at the time of his death, a fixed place of abode has some property, not relevant in our case. F, not relevant. Now, your lordship will kindly take GA 121 of 2018 because that is a document, that application admittedly, even according to submission of the caveatrixes, had already been served. The contents of that application were already known to the caveatrixes. Now, if your lordship for a second kindly takes very quickly GA 121 of 2018, and your lordship kindly at internal page 2, the pleadings commence. And if your lordship tallies, maps the requirements of 278 with the contents, the time and place of deceased death, A, the said depoction, the deceased above named lately residing at so-and-so and permanently residing at so-and-so who has during lifetime departed his life on 25th of November 2017 at Tata Medical Center, so-and-so. A copy of his death certificate is annexed and marked as a letter A. So A is complied with. 278(1)A mentioned in para 1. The family and other relatives of the deceased and their respective residents. Now your lordship will take para 2. The said deceased died, leaving him surviving the following persons. If your lordship kindly turns over, Roma Shen, mother, address. Shorbori Shen, widow, address. Sanipak, Sikh Sanipak. Dishari Shen, minor daughter, address. And the widow is the caveatrix. So B, complied with. C, the right in which the petitioner claims. The legal heiresses so-and-so have not consented. The particulars of the... I'm coming back to para 5. 6, the petitioner states that the deceased son of the petitioner had died. So the right in which the petitioner claims as the mother. Now, the amount of assets, 278D, the amount of assets which are likely to come to the petitioner's hands. Para 5, the particulars of the estate of deceased above named likely to come to petitioner's hand as far as your petitioner is aware or could ascertain are set out in affidavit of assets. And the fact that the affidavit of assets as annexed to GA 121, which is also the affidavit of assets annexed with the PLA, has been disclosed and received by them is not disputed. So all of the ingredients of the contents of a letters of administration, a petition for letters of administration, all of these ingredients have been disclosed in GA 121 and they are to the knowledge of the caveatrix from the GA 21. Now your lordship will very quickly take the fact that these are admitted in their affidavit in opposition to GA 6. I'll just read, I'll indicate. On or about second week of January, 5A, paragraph 5A, on or about second week of January 2018, I had received a copy of the application being GA 121. I had just placed the relevant paragraphs of GA 121 filed by my mother-in-law in connection with PLA number 8. Though no copy of PLA number 8 was served on me, inasmuch as from GA 121, I came to learn Mrs. Roma Shen had filed an application for obtaining letters of administration of estate of my deceased husband without any will annexed. On the advice of my erstwhile advocate, I had lodged a caveat in connection with PLA number 8 of 2018. And this GA 121 I have already shown also contained the affidavit of assets. That is at para 5. So all the requisite information forming part of the PLA petition is disclosed in GA 121 in toto, in seriatim, and they admit complete knowledge of three things. A, GA 121 and the contents thereof, which tallies with all the ingredients of 278. The affidavit of assets as annexed with GA 121, and the fact the mother has lodged an application for grant of letters of administration without will annexed. And in my submission, that is, those are the only information, sufficient information for the caveatrix to file the necessary affidavit in service, affidavit in support of the caveat. I had also shown from the perusal of Rule 25 that the content and purport of affidavit in support of the caveat is confined to two things, Rule 25. One, the relationship, the capacity in which the opposition to the grant is being made. And two, the grounds of objection to the grant. Yet, admittedly, despite expiry of the stipulated period, nothing was filed. And admittedly, despite lapse of more than 7 years, nothing has been filed yet. And today, the direction that is sought, the prayer that is sought in GA number 5 is not of filing an affidavit in support of the erstwhile caveat, but the prayer is for lodging of a fresh caveat. And I had extensively dealt with what is the purpose of a caveat. It is merely a notice, intention to participate, nothing more than that. I'm not repeating that. Now, if your lordship will kindly take.
Yes.
So my argument that whatever are the contents of the affidavit in support of a caveat, those are confined to the relationship and the objection to the grant. They had all the requisite information and knowledge for filing that. Rule 25 nowhere envisages that it is only upon disclosure and service of the PLA that they would be entitled to file the affidavit in support of the caveat. That is not the purport of an affidavit in support of a caveat. It is merely to disclose the relationship, the capacity in which objection made, and the grounds of objection under Rule 25. Now, what is the consequence? Now, before I just conclude my argument, one last thing, the explanation for the delay. Everything admitted, PLA was filed before the caveat was lodged thereafter. Despite that, your lordship will kindly take just page 3, one paragraph, their explanation. 5F. And this is unequivocal admission. Though it is a fact, your lordship has found that paragraph. Though it is a fact that the initial caveat lodged by me sometime in January 2018, which I had lodged through my erstwhile advocates, had slipped my mind. At this juncture, I had just lost my husband, and due to all the turmoil which happened in the interregnum, I had forgotten to intimate my present advocates of the same. It remains a fact that the citation was not issued. I have made those submissions. So admitted, PLA filed upon knowledge of the fact of the filing of PLA. 5B admitted upon service of GA 121, citation was lodged, caveat was lodged. Despite that, the caveatrix in her submission, candid averment in 5F, had forgotten to intimate. Those are the grounds. Now, just one last provision, your lordship. If your lordship kindly takes original side rules, Rule 28. Because at the fag end of the last day's submission, Mr. Choyan Gupta had made a statement in zest that I'm being asked to file a written statement without service of the plaint. I will just show that is perhaps misconceived, because an affidavit in support of a caveat is not a written statement. Neither is a PLA a plaint under Order 7. By a deeming fiction, they are deemed once there is a valid ground of objection, and upon a valid ground of objection to the grant being made, when the court numbers the matter as a contentious matter, then the PLA application is deemed to be a plaint, and the affidavit in support is deemed to be a written statement. I will just read Rule 28 once, your lordship. Upon the affidavit in support of the caveat being filed, notice whereof shall immediately be given to the caveat of the petitioner. The proceedings shall, by order of a judge, upon application by summons, be numbered as a suit. So it's a legal fiction in which the petitioner for probate or letters of administration shall be plaintiff and the caveator shall be defendant. Now, next sentence is very important. The petition for probate or letters of administration being registered as and deemed a plaint. So it is by way of a legal fiction. Plaint filed against the caveator and the affidavit filed by the caveator being treated as his written statement. So it is not formally a written statement under Order 8. It is deemed, and the ingredients and the nature of the affidavit in support are already stated in Rule 25. Such affidavit shall state the right and interest of the caveator and the grounds of the objection of the application. So this argument that for me to file a written statement, I need a plaint, is perhaps misconceived, is perhaps a red herring, because all the requisite information, all the requisite necessary information are already to the knowledge, admittedly to the knowledge of the caveatrix, because they have admitted to receipt of GA 121. I have mapped the contents of GA 121 to the ingredients and mandatory contents of a letters of administration application under Section 278. Accordingly, there was never any prejudice, any impediment to the filing of the affidavit in service. Now, today, in hindsight, this is sought to be done so that this entire process can be protracted. And the prayers that are sought for in GA5, in my humble submission, cannot be granted. Those are unknown to the procedure, because the procedure does not envisage lodging of a fresh caveat. Because once the caveatrix admittedly has information, knowledge about the pending PLA, and she has already objected to it, there is no way to whitewash that state of understanding and knowledge and again a procedure for relodging of caveat. And that is nowhere envisaged in Chapter 35. Those are my submissions. I have already cited Nandalal said, I have given the reference. If required, I will reply after Mr. Gupta has completed his submission. Those are my submissions.
Why he is not here? On the last day, he said that he will take 5 to 10 minutes to conclude. Mr. Kumarjit Banerjee, runner for petitioner, concludes his argument. For the respondent seeks accommodation to place his points of argument. The next week,
Lordship is keeping it on next Thursday. Very. I'm very deeply obliged to Lordship.
next Thursday. এই বইটা ওনাকে দিয়ে দাও, বইটা মনে ওনার
Number 2. In item number 2, my lord. In item number 2, my lord.
GA 24 and 25, my lord, these are came at my instance. This is my application.
In item number 2, my lord, I am appearing for the original petitioner number 3. Now, my lord, this is a matter which has created a lot of problem, my lord, in terms of running the trust. Now, my lord, an application is before your lordship, my lord, GA 15 of 2024.
Don't have any application.
For the permission, the receiver is unnecessarily impeding the progress of the proceedings. Here is a receiver who has gone up to the division bench and has lost the matter and has earned the umbrage of the division bench to be reported to the Chief Justice for action. Today he is coming and wasting the valuable time of the court as well as my endeavors to prove to your lordship that formation of the board can take place.
My applications,
The receiver cannot hold on to the property as a legacy. He has no axe to grind in the matter at all. It is not his private property.
Who is he?
He is every time
There is no application. This is my
individual time.
Let me open my.
Stopping the working of the trust. The settler's intentions are going down the drain. And
these are my applications, my lord. Let me make sufficient.
New applications. This matter has come at our instance also, my lord. We were imploring your lordship and lordship be kind enough to take up the matter, my lord. Kindly allow.
Mr. Basu,
My lord.
It is informed by the court officer
that
some of the I applications, the application which are listed has not been received from the department. Department is directed to place the I applications or interlocutory applications which have not been received by the court positive on the returnable date. But date bolun lagbe apnar এটা after
my lord, I am beseeching your lordship, my lord, because my lord, I'll make it very candid, my lord, because one of the properties that is involving our advocates' chambers on the 10 Old Post Office Street, my lord, the lift is out of order.
Doesn't
have climbing stairs up and down. If your lordship can kindly, my lord, if it take up the matter next week, then I can make my submissions.
Make submissions at the same time. What
23rd.
is happening, my lord?
কবে আসছে
23rd my lord, 23rd my lord,
ডেটটা কবে আসছে দেখো বলে দাও
23rd my lord at 2 p.m. at 2 p.m.
So Basu, you have
3
filed
p.m.
petition.
No application.
No, no,
He doesn't have
My
any.
lord, I have filed an application, my lord, GA number 15 of 2024. That is my only request, my
The
lord.
31st.
GA number 15 of 2024.
You open
31st.
your case.
31st.
Lordship.
Will my lord give me, my lord?
31st of August.
31st.
31st, my lord, may it be
Failing in my duty, my lord, only just to.
No, no, you succeed. Come on.
My application come with a new motion.
Let it appear as a new motion because new application, there are two applications.
Court order, my lord,
Not
my
two
lord, duty to
applications.
point it out to your lordship, my lord, division bench order. That's all. To keep it on
my
record.
lord, receiver, my lord,
Here also you,
receiver can show that he is the owner of the property, but I have no objection.
earlier also you placed the order of the division bench.
That's, my lord, Paras, my lord, just a Horish Tandon's order.
Yes.
No, my
But
lord,
I shall place to these orders. But I shall
My
place. My application, I shall place it.
My lord, on the 31st, my lord,
a review.
No,
No, my lord, this is the, my lord, can record that, my lord, I placed it on record before your lordship, my lord.
Also,
and that was not been called on.
my lord, receiver getting castigated by the division bench, my lord, he is coming and wasting time here.
That's all.
Let him save his skin there.
Submission.
What is he doing here?
Who is he?
Milord, in that event, Milord, I have one further submission because a recalling application is pending.
Nirmalu Dasgupta, learned advocate for your applicant in which?
My lord, petitioner number 2
Petition number 2
in ACR.
in ACR 2214 of 1987 submits that a review petition was filed against the order of the court dated 1st October 2024,
2024.
which has been dismissed with cost to be payable by the receiver. He places the order of the Honorable Division Bench passed in RVW of 46 of 2024, which is taken on record.
Milord, I have one submission because a recalling application to this dismissal has also been filed. Milord, kindly record this.
I have filed an application for
The receiver is clinging onto the property like a private property. I don't know what access he to grind. He can take his retirement and go.
the court and make a submission.
Recalling application to order dated 8th May 2025 has also been filed.
Realized.
Who
My lord, on the
application?
31st, will it commend your lordship to take up the matter on a fixed time, my lord, at 3 p.m., 3:30, whichever suits your lordship on the 31st, not so that I can get some audience, my lord.
If you are
I am trying very hard, my lord.
Who is it? Don't know
I am trying my utmost, my lord, because for the benefits of all.
if your item is not proceeded by any other item, then it will be the top item.
I'm,
Huh?
I'm deeply obliged, my lord. I'm deeply obliged.
the court and make submissions, my lord. It becomes easier.
Okay, he will come, but I cannot direct him.
My lord, because we do not know what is happening, my lord. Somebody is
Okay,
making
okay,
submission.
okay. We'll see.
Whether it's a party.
Thank,
I'm
thank
deeply
you.
obliged.
Thank you. Thank you.
Deeply obliged.
Lordship, this is my application for recalling of an order dated 13th January 2025 passed in this suit, Lordship, by your
Number 6 also, receiver to file an application for recalling of the same order.
same order.
Yes. Both the matters.
Lordship, I'm an intervener in this suit, Lordship. This is in the nature of a pro-interstate suit. This is a partition suit among the co-sharers, your Lordship.
Which order recall?
Lordship is 13 January 2025, which is appearing at page 164, your Lordship. Volume 2, your Lordship.
Service?
Lordship.
Service of the application?
Lordship.
Service.
Uh,
Affidavit of service.
Lordship, it's already on record, Lordship. The
So?
They are also praying for recalling of the order.
Same
Person who obtained the order is order also
Find the application for recalling of details amount.
Lordship, we had all.
Item number 6.
Lordship, this was appearing before the regular bench, but my lord was pleased to release the matter because this was in connection to the recalling of an order which was passed by your lordship.
Affidavit.
Lordship, I had filed the same at the time of filing of the application. I'll find out from the department.
Inform that affidavit of service has not been filed.
Lordship, I'll find out from the department, your lordship.
Complete service. Your application is?
Well, that is item number 6.
Lordship, may kindly hear me out. They are already appearing, Lordship, the joint receivers. Lordship, the reason that I've come before your lordship, the recalling of the order is a major fraud that has been played by the joint receivers upon the interveners, your lordship. They have suppressed orders, applications. Lordship,
Applicant of GA 206 of 2020 has to be informed.
Lordship, they have been informed. They are the joint receivers, your lordship. They are already appearing, your lordship. Lordship, at the time of filing of the application, we had filed the notice of motion.
274.
I'll still find out from the department, your lordship, but they are already there, your lordship. The respondents are already here. It was their application that they had taken out, praying for leave from this honorable court to sell some of the properties, the joint properties, lordship. Lordship.
So in the order which was asking for recalling, whether there are certain apparent mistakes, so we have also called for recalling of the order.
This is not apparent mistake, your lordship. My contention is very different from whatever apparent mistakes they're talking about, your lordship.
Hard to get.
Lordship, it cannot be heard to.
In 274?
Yes. Yes.
Where is the affidavit?
Lordship, I'm not a party to that application. How it could be heard?
1 second.
Lordship, if
नहीं तो? কি করতে হবে?
Then, my lord, kindly fix another date. We shall produce.
273.
Lordship, as far as my application is concerned, I'll find out from the department because I had already filed my affidavit of service, Lordship, with the department at the time of filing. Lordship.
Application for recalling order dated.
Lordship, one kind indulgence, Lordship.
2025. Huh. During the course of hearing, the service upon the applicant of GA 206 of 2020
Lordship, I have a copy of the notice of motion that I had filed in court. I have a copy of the affidavit of service which I had filed in court.
This court. At this stage, learned advocate for the petitioner seeks to take proper instruction and information from the department concerned. Oh, sorry, she submits that her client has filed the affidavit of service. However, she seeks to take proper instruction and apprise this court accordingly on the next date. কবে যাচ্ছে দেখুন GA 274A.
Lordship, there was
for recalling order dated such and such 13th January 2025. Learned advocate for the petitioner seeks accommodation. It is general.
Lordship, there was some urgency in the matter that we, the Lordship, the interveners are scared that they might sell off those lands, which in respect of which an agreement for sale has already been entered into between us.
We ourselves have asked for recording, so why should we transfer? We are not doing anything.
Lordship.
Next week also.
This is my application. My lord will remember this is that application where the same property was sold twice by the learned receivers. Other side was arguing. My senior has completed the argument.
My lord, I'm led by Mr. Shaunak Bhattacharya. He is appearing on behalf of the respondent. He is engaged in courtroom number 26. Kindly give a short passover so that he can appear.
This matter is, my lord,
He is in the middle of the hearing in courtroom number 26. Kindly give a short passover.
Sir, may we cannot wait because we are interested in this case. So if we get a copy, we can intercede by your an application. What? Because we are interested in the sales and that. We are the owner. We are the owner. Two brothers were the tenants. They fought and filed the case and obtained out. Our property right is going to be held.
you are the plaintiff.
If you want to intervene, then an application has to be filed.
Yes, yes. But we have got no copy, so we are without constated we can file here.
Lord, if they are appealing for the plaintiff of the suit, my lord, then
We are the owner of the property.
then you make an application.
So make an application without the copy, we are not getting the consent. Copy ready to pay the.
My lord, suddenly, my lord, this my lord, learned friend is appearing, saying he is the owner.
When we have got there are property right.
People ask me,
Just give a copy at our cost, we say. Xerox it. Let them supply us a copy. At our cost, we shall make it photocopy.
that direction cannot be given.
Without cost that we cannot file the application. And also we do not put the facts of the case.
How can I direct them without there being any?
There's just request. We are requesting. Given it a copy. Xerox will be.
This matter is continuing for the last 4 years.
Sort it out amongst yourself. Right? No court orders can be passed. Because he was arguing this matter, the matter was sent to the Honorable Chief Justice.
Yes, my lord.
The Justice sent past the order. Thereafter came back on assignment. For several days, the respondent was not appearing. After that, Mr. Bhattacharya came. Again, the argument started. Mr. Bhattacharya started. Now he is busy in some other court. Now you say that I want to intervene. If you want to intervene, intervene. How the process, which process has to be taken up, you find out. Where is he?
26. After 26.
Well, the matter is called on when we are lucky. Your lordship knows. And if they take the adjournment, my lord, then I don't know when it will again called on.
নেক্সট উইকে আমরা যখন নেব তখন কটার পরে থাকবে এটা? নেক্সট উইকে যখন নেব এটা কটার পরে থাকবে? ওই এটা ওইটার পরে এটা থাকবে। Accommodation is sought for on behalf of Mr. Shaunak Bhattacharya, learned advocate appearing for respondent. Is this matter? এটা নেক্সট উইকে একটার পরে থাকবে।
But can it appear on the top note, item number 1?
One item. Here is one item after that.
3:30 p.m.
You're taking up at 3:30 or you?
All to holo. Gratefully.
Thanks to the petitioner in this matter, my lord. This was originally my probate application, where now I have also filed an application for discharge of the probate. The preliminary ground for my application is the fact that the person who has entered as a caveator, rather entered appearance as a caveator, is the son. But my lord, the argument that I have proposed before my lord is the fact that this son claims to be the actual person who is the owner, claims a title which is adverse to the title of the testatrix. In such facts, the son could only approach a civil court, because the probate court does not decide the issue of title. So, my lord, my initial submission was that the caveator cannot don two hats at the same time. If the caveator is to say that he is disputing the title on account of being it a mitakshara property and the mother was holding the particular property on behalf of the son, who was a minor at that stage and was given this particular right, which if my lord takes up paragraph 14, my lord, paragraph 14 of the, my lord, this affidavit in support of the caveat, my lord. The affidavit in support of the caveat, paragraph 14.
Affidavit in support of
Sorry, affidavit in support of the master summons, my lord. Paragraph 14. In the case in the said affidavit is that the properties of the testatrix is out of the shares inherited by the caveator from his grandfather under the Mitakshara family law. The caveator is claiming an interest adverse to the interest of the estate and or the testatrix, therefore he has no caveatable interest in the estate of the testatrix, as he alleges the testatrix could not have been the owner of the properties bequeathed by her in the said last will. Therefore, the caveator, even if a relative, is claiming a right adverse to the estate and is required to be resolved before a civil court. So, my lord, this is the this was the main contention which I had proposed, and for on this contention, my lord, I had relied on two judgments of the Bombay High Court to indicate that any person, whenever is disputing the right of the testator or testatrix in this particular case, my lord, if the person is disputing judgment, judgment গুলো আছে দুটো। It may come back to my lord that I had shown the Birla judgment where paragraph 86 C3 I was relying on for the purpose of when there is no caveatable interest.
Yes.
And my lord, specific reference as I was indicating paragraph 14. Paragraph 14 was on the basis of the statements made in paragraph C, 7C at page 4 of the affidavit in support of the caveat.
Affidavit in support of master summons.
Of the caveat, my lord.
Caveat of affidavit.
The affidavit in support of the caveat. My lord, I believe the GA application is here. The affidavit is support would be with the main PLA matter. My lord, in that case, my lord, may I hand over my copy, my lord, which I had filed, just to show, my lord, the particular reference. I'll
ঠিক আছে।
my lord, page 3 at the bottom. It is stated, page 3, if my lord takes up paragraph 7C, it starts that it is stated that my mother Chaya Rai Chaudhary was not only the widow of so and so since deceased, a well-known wealthy citizen of the then Calcutta, having fame and reckon with the aristocratic society of the city of Calcutta, being the grandson of Zamindar so and so, a Hindu Kshatriya Zamindar governed by the Mitakshara school of Hindu law, who happened to be the original owner of the premises numbers 52H Beni Nandan Street, besides properties being premises number so and so, which we are not concerned with here, my lord, which are subsequently amalgamated and renumbered as so and so. That apart, my mother had sufficient rental income received from the property as well as property so and so, as well as monthly interest received from substantial deposits of various banks. Furthermore, I, being her son, used to give pocket expenses to my mother besides taking care of her from day to for her day-to-day needs. My lord, thereafter, my lord, kindly comes to paragraph E, that after the preliminary decree was passed and during the pendency of the final decree was to be passed, my father died intestate, and thereby my mother, being the deceased above named, was substituted in the place of my father, and I was put already party to the partition suit. In the said suit, the final decree was passed on so and so in terms of a compromise amongst the co-sharers. Since the suit was decreed on the basis of the terms of compromise, irrespective of the fact whether my mother Chaya Roy Chaudhary was a necessary party in the partition suit or not under Mitakshara School of Law. However, she opted for the guardianship of the caveator herein, who was a minor at the point of time under the Mitakshara School of Law. Under the Hindu Succession Act, she was allocated the premises on the basis of the compromise decree. And it is stated that then G, the terms of the joint decision of all the co-sharers, our dwelling unit at so and so was supposed to be sold out, for which my mother's residence therein required to be shifted, and thereby, by making provision in the said compromise decree, the residence situated at so and so and PS so and so was allotted to my mother out of the 1/3 share in the partition suit. That from the sole process of the, this is in respect of the other property, my lord. So he deliberate and he indicates that with regard to residence situated and so was allocated to my mother, and irrespective of the fact that I and my wife regular basis have made substantial payments to my mother. So, my lord, the main contention is that my mother did not have a right. It was only allocated for the purpose of her residence. Whereas in the will, and on the basis of the compromise, the caveatrix had indicated that she was the owner and she was transferring her title. Now, whether the issue of title of the property was with the mother on the basis of the compromise decree or not cannot be decided by the probate court. In that case, he may have to file a civil suit for the purpose of getting this declaration that the mother was not the owner, it was only a residential right allocated to her. The probate court is only to look whether this particular will was executed into. If he is coming in as a legal heir and is challenging his right in respect of the particular will, and saying that because I am a legal heir through inheritance, I ought to have gotten the particular property, he has a caveatable interest. And I cannot deny the fact that a son would not have caveatable interest. Definitely the son has a caveatable interest. But when the son comes and says this was not her property, at that stage, the nature of the particular probate proceedings would change because the son is seeking a declaration that my mother was not the owner. The probate court only looks whether a will has been executed, the caveatrix, whatever she tried to devolve onto by way of the testamentary disposition, that would take place. So, my lord, I had placed the judgments in the KK Birla Lodha case where paragraph 86 I had relied on, that unless only in case where there is an adverse, the caveatable interest is not to be exercised in cases where adverse presumption is drawn on the title.
Exclusive properties of Chayara.
My lord, my learned junior wants me to indicate that I had also argued at paragraph 31 and 32 of the affidavit in support of my master summons. I have filed the decree on the compromise decree on the basis of which I am claiming that the testatrix was the owner. At page 31 and 32, my lord, the numbering is on the top right corner, my lord. These pages have two numberings. It was taken from a 31, my lord. Right at the bottom, B, that the property specified in Schedule D herein under written, namely premises number 52H, Beninandon Street, shall be exclusively allotted to Chaya Roy Chaudhary, over which other parties shall have no claim or any nature whatsoever, and the same shall be treated as exclusive properties of Chaya Roy Chaudhary, the defendant number 9 herein. So this is how the testatrix had gotten the property in her favor. And the caveator does not dispute that he was not a party. He was a party. He was a minor. There are other provisions where it would, from the particular decree, it would be shown that he has got his share as well. We are only concerned with 52H Beninandon Street premises, and that is what has been subsequently made over, because there were several other premises, 3 groups. The mother and the son were part of one group. That is, so today in this probate proceedings or the particular application, that may not be very necessary, my lord.
Okay.
So, my lord, I had also indicated in terms of the following the Birla judgment, there are 2 Bombay High Court judgments which indicate once any person.
Bombay? Which one?
There is no dispute that in a probate court or the probate court can decide title or not. There is no dispute.
Did
That
you have
probate court-
concluded? You have concluded?
Yes, my lord, concluded.
So, my lord, from the pleadings or from my affidavit in support of caveat, it has to be looked whether I have challenged my mother's title or not. Mayor saying that she was allotted, and without disputing that, it cannot be said that I am challenging my mother's title. Whereas I admit that the property was allotted to my mother. I never said a single line that it was not her property. I have never disputed it is not her property. I admit that irrespective of the fact she was allotted property, irrespective of the fact that we have given fund, this particular property was allotted to her. We never disputed. So the question of my lord, challenging the title does not come here. So the reference to the judgments are not applicable. In what context I said the property was allotted to her, and we in the event, my lord, if my lord takes up the paragraphs my learned friend, my lord, referred, para F.
F of?
My support. Evident support. That copy was handed over. Para F, last 2 lines, 3 lines. She was allotted premises number such and such on the basis of the said compromise degree. Para F, page 5. Paragraph last 3 lines. My lord, got it? Last 3 line, my lord. She was allotted premises number such and such on the basis of the said compromise degree. Whether I have made any challenge to that degree? Question answer is no. I admit that. So the question of challenging her title does not come arise. He is interpreting in one way that is not there. No words are there from which it can be gathered that I have challenged the title. Rather, I admit. Para G, he has referred. May I read for Para G?
Yes.
That in terms of joint decision of all the co-sharers, our dwelling house situated at such and such was supposed to be sold out, and for which my mother's residence therein required to be shifted, and thereby making provision in the said compromise degree, the said residence situated at such and such was allotted to my mother out of my 1/3 share in the said partition suit. I am disputing anything. What they are saying, I am admitting. Whether it starts with the language that I dispute that the partition degree is not binding upon, the compromise degree is not binding upon. It is not there. I am admitting this. In what context I have said the devolution of the property to my mother? That will argue in the stage of my lord trial or hearing. Because if I disclose it will, my lord, cause difficulty in my cross-examinations. Because why I said so? From this, well, it cannot be gathered that I am challenging my mother's title. It is not. I have just narrated the devolution of the property, how the mother property got the property. This much. My lord, if my lord reads the entire, my lord, support, my lord, it will gather, my lord, that I made the sequences how she got the property. Referred to para H, he referred, my lord, that from the sale proceeds of rupees 1,91 crore for the said property of such and such, my mother was allotted rupees 56 lakhs for her maintenance, irrespective of the fact that the residence situated at such and such was allotted to my mother. So, whether I am disputing that the property was not allotted to the mother or wrongly allotted, it was there. No such contention is there. Wherefrom my learned friend is gathering that contention. They are challenging the, my lord, the title of the testatrix.
Yes, next.
Para Q, page 8. My lord, got it? That on March 26, 2020, most unfortunately, my mother, being the deceased name, died at her premises at such and such. What remains? I am challenging title of my mother? No. Nowhere it is written. This application is unnecessary filing. They have filed without putting the cost or transferring the, my lord, the probate petition as a testamentary suit, which by they file an application seeking an order to, my lord, to transpose this application as testamentary suit. They filed an application. After that, they have filed this application only to delay the proceedings. If the will is genuine, prove it and got the property. We have no difficulty. Why they are shying away by filing one after application? Whether they have put the requisite stamp duty as ordered by the Honorable Court earlier?
Keep quiet.
Aras, my lord, I could not conclude today, my lord. It would be difficult for concluding.
You will take time.
I will take time. I will take
How
time.
long?
Another, my lord, 15-20 minutes. Because today I'm little bit handicapped. My junior is not there and entire brief is also. Thank you. Thanks. Reading
My
from
lord, one issue is there, my lord, the fact that has been made out, even when we had argued this case initially, my lord, the stand has changed, even in their affidavit, for the completion.
Let him complete then you.
Very well, my lord. I will indicate that what he has actually case made out and what he is arguing today is different. My lord, the affidavit in reply was served on him, but it was not put in the record, my lord. May I file it today, my lord? Much obliged, my lord.
Affidavit in reply filed by the, you are the applicant.
I'm for the
Right,
applicant, my lord.
Applicant. To the affidavit in opposition of the caveator is taken on record. Copy served. Copy.
I have given, I have served.
even in para H, para,
Even if he doesn't have it, if he tells me, I'll give it to him. No problem, man. He's little handicapped today.
So Ratul Das, the advocate for the applicant, concludes his argument. Uday Naran Betal, learned advocate, seeks accommodation to place his further arguments.
I've started my argument and
due to Uday Naran Betal, learned advocate for the caveator, this is his argument. However, he seeks some accommodation to place further arguments.
Paucity of time.
Probable. Not please. Next week.
Next week.
Yeah, side news, you know.
May it come the week after, next Thursday. I'm in some difficulty because of professional reasons, my lord.
So Betal,
31st.
31st.
And may I have the liberty of taking the affidavit in support of the caveat which I had handed over.
My lord, let the affidavit in support of caveat or the entire file may be brought on record. Directed to the report.
Any other application is pending which has not been.
My lord, there is one other application which is GA3, my lord.
That is the application for converting.
Oh, that was the application for numbering it as a testamentary suit. After that, I have filed
That is the
GA6.
only thing that is required in this proceedings. Compilation can be given by.
I may hand over a compilation next day, my lord. I will do that.
That will be sufficient.
I mean, a copy the other way. Much obliged, my lord.